Every book ever written might be, technically, a training document. Not metaphorically, literally. When you feed a neural network the complete works of humanity without asking, you might be building something remarkable, or you might be running the largest intellectual property heist in history. The interesting part is that both of those things can be true at the same time. Here's how large language models actually learn. Imagine you want to teach someone to understand language by locking them in a library for 10 years, no windows, no outside contact, just books. Millions of books. Romance novels, tax code, Reddit arguments, Dostoevsky. Through sheer pattern recognition across all of it, they start to understand language itself. That's essentially what AI training is. Except the librarian forgot to buy the books. When Meta set out to build Llama, their flagship language model, engineers needed data. Enormous quantities of it. They reportedly turned to datasets like LibGen, a shadow library containing over 7 million pirated books. Publishers and authors alleged this wasn't accidental. Internal communications reportedly show executives knew the sourcing was legally problematic. The technical term for knowing something is wrong and doing it anyway is a decision. The lawsuit names Mark Zuckerberg directly. Not just as Meta's CEO in a general sense, as someone who, according to the complaint, personally authorized and actively encouraged the use of copyrighted material to train AI systems. This distinction matters enormously. Corporate liability and personal liability are very different legal conversations. It's the gap between the company made a mistake and a specific human being made a choice. Courts tend to focus on that gap. Scott Turow, novelist, lawyer, and former president of the Authors Guild, is among the plaintiffs. His argument is almost arithmetically simple: he spent years writing books. Meta spent milliseconds ingesting them. The asymmetry isn't just economic. It's cosmically rude. His words, quite literally, went into building a system that can now produce prose faster than he ever could. Here's where copyright law starts to feel like a 19th century map of a country that now has highways. Copyright was designed to protect an author's right to reproduce and distribute their work. But training an AI isn't exactly reproduction. The model doesn't store your novel, it absorbs statistical patterns extracted from it. Whether that constitutes copying is genuinely unclear. The law has a gap, and it is approximately the size of the internet. The economic stakes are genuinely enormous. If training on copyrighted text is ruled legal, AI companies win access to centuries of human creative output essentially for free. If it's infringement, they owe licensing fees that could structurally reshape the entire industry. Neither outcome is obviously fair. Requiring payment for every training example might be practically unworkable. Allowing unrestricted use effectively strips creators of the only leverage they've ever had. We built the most powerful text-generating systems in history largely on the work of people who had no idea they were contributing to them. The authors didn't consent. The publishers didn't negotiate. The question courts now face isn't purely legal, it's foundational. Who owns the patterns inside a mind? If you can extract those patterns from someone else's work without permission, then authorship isn't just devalued. It becomes, quietly and structurally, optional. Strip away the courtroom language and what's left is this: a new kind of mind was built from an old kind of labor, and the people who supplied that labor weren't in the room when it happened. The lawsuit exists because copyright law is the only tool available, not because it's the right tool. Meta may win on technicalities. The authors may win on damages. Neither outcome resolves the underlying tension, which is that we've created systems capable of absorbing creative output at industrial scale, and we designed no mechanism, legal, ethical, or economic, to account for the people that output came from. The gap in the law is real. So is the gap in the story we tell about how AI gets made. What strikes us isn't that Meta used the books. It's that the argument "we needed the data" has become so normalized that it barely registers as a justification anymore, it's treated as an explanation. We don't think the engineers were villains. We think they were operating inside a system that never asked the question out loud. And that's the part that lingers. Because the books are already inside the model. The patterns are already extracted. Whatever court ruling comes down, that fact doesn't unwind. So here's what we keep coming back to: if the people who built these systems had been required to ask permission first, not just legally, but actually, human to human, do you think they would have built them differently, or do you think they simply wouldn't have built them at all?